Great, thank you, Liz. So I am Britt Berner, and as Liz said, I am here to discuss Understanding Trust Part 1. Today we're going to talk about what a trust is. We are going to talk about revocable trusts and why they might be a good thing and they might be something that you need. And on Thursday, Robin will discuss irrevocable trusts and the benefits of that type of trust. I want to start out by saying that not everybody needs a revocable trust. There are articles out there and there are people who go online and speak about this who say everybody needs a trust, everybody needs to avoid probate, and that's just not the case. So it's very important to realize that everything when it comes to estate planning is going to be very person specific, very fact specific, and certainly very state specific. So anything that is to a national audience, you really need to listen to it, but then also realize that you're going to need individual advice for your circumstance and also the state that you're living in and the laws within that state. So first, we're going to talk about what is a trust. A trust is first and foremost a document. So just like a last will and testament is going to say how you want your assets to be distributed upon your death, and who you want to be the executor who's in charge of all of that, a trust is also a document, and it tells you the rules of the game. The difference is that a trust, when created while you're alive, a living trust, is a trust that might own things while you are still living, and it exists while you are living, rather than a will that just takes over at your death. So this document, I like to say, has the rules of the game. So when someone says to me, I have a trust, can I do X or can I do Y? My answer is, I don't know, I need to read the trust. And that is why trust documents, if written properly, are often a little bit lengthy, because it governs not just what happens while you're alive, but also what happens then if there's subsequent incapacity, and also governs what happens at your death. These are three very different circumstances. The person who is in charge of the trust may change at each juncture, as well as who the beneficiaries are and how the assets in the trust can be invested, how they can be spent. So it's very important that all of those rules are in the trust document. I like to think of a trust as a piece of reference material, not a book that you're going to read through start to finish over and over again, but more a document that hopefully has a table of contents. And when there's a specific question that comes up about how something should be dealt with, you go to that section of the trust and you can figure out what needs to be done. So it's very important that the trust document has all of the rules of the game. So again, it's going to deal with while you're alive and well, if you have any incapacity, and then at your death. The trust can include things like who is the trustee at each juncture? Is it you? Is it somebody else? Does that change at each point? Is there an ability to appoint a successor? So if I'm the trustee of my trust, maybe I'll say that the person who's successor trustee, the person who serves after me, that they can appoint whoever might have to serve after them. How does a trustee resign? Do they do it in writing? Who do they have to notify? All of these are things that will be written in the document and actually spelled out so that people know how to properly behave to keep up with the rules of the trust. Another important thing that the trust is going to say is who are the beneficiaries? And again, who the beneficiaries are may change based on the step of the trust that we're at. So if I have a trust that I'm in charge of, I may be the beneficiary while I'm alive and well, and I can be the trustee, but I can also make anybody else the beneficiary. I can use the assets for anyone I choose, my children, my siblings. But perhaps upon my incapacity, I want the trust to say that at that point, when someone else is trustee, because I can no longer serve, that somebody will say, maybe at that point, I want myself to be the only beneficiary, because I want to make sure my needs are taken care of if I'm unable to handle things on my own. And then upon my death also, who will be the trustee? How will They hand out the assets, who will be the beneficiaries. All of that very important to be in the trust document. So first and foremost, it is a document, but secondly, a trust is an entity. It owns things. It is not living and breathing like we are, but it can own things just like we do. So a trust will have a tax identification number. Now today we're talking about revocable trusts, and in most circumstances, if not all, a revocable trust that I create for myself while I'm living will carry my own social security number as the tax identification number. Robin will talk about reasons why we may assign a new tax ID number, or EIN, employer identification number, to a trust, and there are circumstances in which that is done. If I have a revocable trust that has my social security number while I am living, then upon my death, when it turns into a trust for the benefit of others, or a trust to take care of the administration of my estate, at that point, if I'm no longer living, my social security number cannot be used to identify the trust any longer, and a new tax ID number will be assigned at that time. So the trust is an entity. It owns things. How do you allow a trust to own things? So I'll give a few examples. A home. If I have a house and it's deeded in my name and I'm the sole owner, I can transfer that house by deed to my trust. So Britt Berner can give a property to the Britt Berner Revocable Trust. That deed is then recorded with the county in which the home is located, and now the owner of record of that property is the Britt Berner Revocable Trust. And that is how you actually make it so that the trust owns things. Another example, if you have a bank account, a checking account, and you want it to be a trust checking account, you will go to the bank and you will give them a copy of the trust, and you will say, I would like this bank account to become a trust bank account. And they will have procedures for you to follow. And when you get that bank statement in the mail the following month, it won't say Britt Berner on that bank account anymore. It will say the Britt Berner Revocable Trust, Britt Berner as trustee, assuming I am the trustee of my own trust. Similarly, with an investment account, there are change of ownership forms that you can get from the institution that holds the account. And you can create a trust account, and the assets can be put into the trust in that manner. Many people come to see us and are a little confused because at the back of the revocable trust document, there is a Schedule A. This is where we often list the assets that the trust owns. It is important to note that merely listing an asset on the Schedule A is not going to be enough to make that asset be owned by the trust. So if we take my example of the home, if I create a trust document and I sign it and I notarize it, and it has to be signed and notarized, signed by both the creator and the trustee, and in my example, I am both, and my signature is notarized, I then have a valid trust. If I then put on the Schedule A the address of the property, but I do not execute a deed putting that property into the trust, then that is not enough. Putting it on the Schedule A alone is not going to be sufficient. You will need to actually go through the process of changing the ownership of that property by deed, as I described. So a revocable trust, as I said, can have my social security number. This is a tax neutral trust. It is not going to change the way any of the assets in the trust are taxed, both during my lifetime for income or property tax purposes, or at my death for estate tax purposes. So those who are trying to do tax planning, either income tax planning or estate tax planning, the revocable trust is a tax neutral document. It will not achieve that goal. So this will not be the right type of trust if that is what you are attempting to do. It will not avoid taxes. as well. So a lot of people think that if they put assets into a trust and they don't realize there's a difference between the many types of trusts, that they can avoid estate taxes at death, and that is not the case. But again, if I am the trustee of my trust and it's a revocable trust, then I should have the power to make any changes that I want to that document. I can change who the beneficiaries are, I can change who the trustees are, I can change the terms of the trust. If I want to make it so that any trustee after myself has to account to the beneficiaries and do a formal accounting, I can make that requirement. I am in full control of changing the document while I am alive. So why would you do a revocable trust? So it's not going to be tax planning. What is it going to achieve? Last week on Tuesday, I spoke about probate and wills and avoiding probate. And that is what probate avoidance is one of the main reasons that people choose to do revocable trusts. So you can go back to our website, bernerlaw.com, and watch last week's probate and will presentation. But just as a quick recap, I spoke about 4 main times that people want to avoid probate. If they're unsure who their heirs are, because in a probate process of a will, those people need to be located. If they have heirs that are their direct next of kin that they are disinheriting. If they have a disabled beneficiary that the court in a probate process might want to appoint a guardian for, which could be costly and time consuming. And also if you own real property in multiple states, because you want to avoid needing to probate the will in all of the states in which you own property. So the example of that is if I have a home in New York, a home in Massachusetts, or a home in New York and a condo in Florida, as an example, those are times where my will, if those assets are all in my sole name, would have to be probated in all of those states where I own those properties. And that is just time consuming and costly, and some people choose to avoid that. So the revocable trust will avoid probate, because probate of your will is done if you die with assets in your sole name with no beneficiary. If I took that house and I signed a deed giving that house to my trust, that trust is now not in my sole name. I apologize. The property is now not in my sole name. It is in the name of my trust. And therefore, at my death, the trust owns it, and the trust says upon my death how that property shall be dealt with. Is it supposed to be sold and the proceeds divided? Will the house go specifically to one person or to multiple people? That is all within the trust document and avoids needing to probate a will to determine how that will be distributed. Another reason that
sorry, Brett, we had one question come in.
Okay, sure.
What is the difference between a will and a trust? Just writing a will would be enough, or need to have a trust also? What are the benefits of each?
Sure. So I think it would be helpful. I'm going to do a quick recap of that, but also I think would be helpful to go back and watch last week's webinar, which is on, as I said, is on our website. So a will only deals with what happens with assets upon your death. A trust, if created during life, will own assets while you were living, will avoid the court probate process, because a will has to go through a public court probate process, and has certain requirements of who's required to receive notice, and that might be people that you don't want to receive it. And the other reasons that I mentioned, when there's a disabled beneficiary or property in multiple states, that the probate process could be costly and time consuming. So again, it's a very personal situation. There are some people who will be just fine and their estate will be administered quite quickly if they have a will which has to go through probate, whereas other people might fall in the categories discussed where probate would be a little more difficult and timely and costly, and therefore you would want to avoid it. So the big difference is trust owns things while you are living. So the other reason that we often suggest that people do revocable trusts is if they are going to have trusts that continue on after their lifetime. So I'll give an example. If you have a person with minor beneficiaries, either a parent with children under 18 or a grandparent who's leaving a substantial sum to grandchildren who are under 18, or any person with these young beneficiaries, you're probably going to want to have a revocable trust that says, upon my death, a trust will be created for child A, and child A's trust will have the following terms, and those terms will be laid out within my original trust document. And what that's going to do is it's going to make it so that a few things. One, when I'm designating retirement accounts or life insurance, I can designate the trust created for that child under my trust. Sometimes we find that these institutions don't want to designate a trust created under a will document. And so this is a workaround that if you are naming minors as beneficiaries. The other thing it does is if you have a will that creates a trust for a minor at your death, there is then ongoing court oversight of that trust, which can be difficult down the line if, say, for example, you need to change who the trustees are, then that has to be done through a court process and can't just be done with the terms that are privately stated in your trust document that you created. This is the same thing for supplemental needs trusts. If you have a supplemental needs trust for a disabled beneficiary, you often will want to create that through a trust document that you created during your lifetime so that there isn't ongoing court involvement with the trust. I'm going to pause now because I see there's a few more questions.
Yes, we have two more questions. Can a co-op be owned by a trust? And is it, these are two questions in one. Can a co-op be owned by a trust, and is it determined by the co-op board?
Okay, great. Actually, the next thing I was going to discuss is co-ops, so this is perfect. I know we have a varied audience, so we have some people who live in freestanding homes, some people who have rentals, some people who have condos, and some people who have co-ops. Co-ops, you do not own the unit you live in, you own shares of the building. You own shares of the cooperative that owns the building. And so when you have stock shares for a co-op, the answer is yes, it is up to the co-op if they will allow ownership by trusts. And very often we end up with clients creating revocable trusts for their co-op to avoid probate, because even though there are certain benefits to the irrevocable trust that Robin is going to discuss on Thursday, those co-ops don't always allow ownership by irrevocable trusts. And so quite often we can avoid probate on the shares of a co-op if we can assign those co-op shares to the revocable trust. But that is a process that we have to go through with the building, with their managing agent. And just like you would do a closing to purchase those shares, they want to have a closing to formally transfer the shares from the individual to trust ownership. And that's very fact-based. The other thing that's important is if we do talk about, and it's important in the co-op context, especially if we talk about Medicaid. Very often we think about the irrevocable trust for Medicaid planning, but the revocable trust can often be used because when people are at home on home care Medicaid, or if they're in an institution, but they have certain exempt individuals living in their home, like for example, a disabled child or a spouse, that home is exempt for eligibility purposes. But the problem is that if that person gets Medicaid eligibility, receives Medicaid services, upon their death, Medicaid is a creditor of the probate estate. What that means is that Medicaid can recover and put a lien on any property that passes through a will in probate, or if somebody doesn't have a will, through the administration process in surrogate's court. And by having your home, be it a revocable trust that owns a deed to a property or a revocable trust that owns shares of a cooperative, you will avoid estate recovery from Medicaid and avoid that lien because the property is passing through the trust. I see there's another question, Liz.
Yeah, so there's another question. If money is left in a trust for the care of a parent which is invested, once money is depleted, do you have to end the trust in some way?
So a trust that owns an asset, if then all of a sudden that asset is gone, there is, so my first answer is going to be to go back to one of the first things I said, which is it depends what the trust document says. So it may be that the trust says that upon termination, there needs to be an accounting to certain beneficiaries. There may be certain things that are in place. But in terms of officially ending the trust, there's not, for example, if the trust had its own tax ID number and the trust now has nothing in it, there's no way to formally turn over that tax ID number to the IRS. There is no formal requirement in the law to closing the trust once the assets are gone. It'll just depend on what the actual terms of the trust say. Another reason that we put assets in trust and we don't just give them to individuals outright is for tax purposes. So I said that this is a tax neutral document. The important thing to know there is that's sometimes a good thing. So it may not achieve certain tax goals for those who are looking for tax savings, but for many, what it will do is it'll preserve certain things, like if my home is owned by my revocable trust, then I still get my property tax exemptions. If I got the STAR exemption or the enhanced STAR exemption for being a senior citizen, then that exemption is still available to me because, as the trust terms say, I am the owner of the trust for those purposes, and therefore I get those exemptions. Another example is if I purchased my property and there's been a great jump in value, and at my time of death, I want my heirs to inherit it with what we call a stepped up basis for capital gains, that can be achieved through the trust. So I'll give an example of that. If I purchased my property at $100,000 and now it's worth $500,000. If I give it to my daughter while I'm alive, she inherited the property with my $100,000 basis, as we call it. That's how I purchased it, with that basis. That's the cost that I bought it for. If she then turns around and sells it, she is paying capital gains tax on the growth between my $100,000 purchase price and whatever she sold it for. Whereas if I put it in a trust and at my death, it's worth $500,000, my daughter can inherit it through my trust at a $500,000 basis, which means if she turns around and sells it for $500,000, she's not paying a capital gains tax based on the growth from my purchase price. This would be the same as if I owned it individually, but as I referred to with the Medicaid context, it will make it so that the property is in my name. It might be exempt from Medicaid eligibility. We're avoiding the lien at death, and we're also preserving that step up in basis for capital gains purposes. All this to say, none of this is something that you should be doing on your own or doing at home. There's a lot of considerations when deciding what type of trust and how it should be done. And again, it's very fact specific based on things like what was the property worth at the time of purchase, what is it worth now, what's the age of the individual, their health, what kind of benefits are we looking to protect, and how that should be done. The other thing that's important about a trust as compared to probate, which we discussed last week, is that it's private. So once you file your will with this, or upon your death, once your will is filed with surrogates court by your executor, it's a piece of public record, and anyone can go and search that public record and see the information. And when you have a trust, the trust termination process at your death is a private process. So for many people, they don't want that to be a public record. They want to keep that private, and so they can do so through the trust process. I think I saw that somebody raised their hand. If you can, just type your question into the question box and we can answer it that way. Okay. So I think those are, I'm just checking to make sure, I believe those are the main things that we want to discuss. Oh, one other issue I want to discuss with co-ops specifically is if you have a co-op and the co-op is somebody passes away in their apartment, the police will come and they will seal the apartment. And the issue that we have had with co-ops is that nobody can re-enter that apartment if the will has to be probated until that probate process is completed. And so we often have I had an example recently of someone who passed away and the children couldn't enter the apartment to clean it out and move it towards sale until the probate process with the court was complete. And that only took about a month and a half, but that was a month and a half delay that they couldn't get in there and get that done. If the property had been owned by a trust, the trustee would have had immediate access to that apartment and could have gone in without any delay to clean the apartment out. Liz, I think we have some.
Yep, so we had one more question. I did an irrevocable trust in 2010 thinking it would protect Medicare recovery. Is that still true? Is it not true of a revocable trust?
So can you just, they said they did an irrevocable, IRR?
Yep, they did an irrevocable trust in 2010 thinking it would protect Medicare recovery. Is that still true? Is it now true of a revocable trust?
Okay, good question. So whether or not your irrevocable trust from 2010 is still going to work is definitely a question that I would go back to your attorney. It's been 10 years. We usually say you should review your documents every 5 years, or if there's a major life event, retirement, birth, change in how you want things distributed. So I would say to go back and review your specific circumstance with your attorney. That being said, the revocable trust is not going to protect for Medicaid eligibility. So for example, if you had a $100,000 investment account and you put it into a revocable trust, you will not be eligible for Medicaid because your assets are above the allowable $15,750. So a revocable trust will not protect in that circumstance. Where a revocable trust may be helpful in a Medicaid context is somebody who owns their primary residence, and their primary residence is exempt because for Medicaid eligibility purposes, because they're living in it or because certain individuals, the spouse or the disabled child, are living in it, in which case we're only trying to protect the property from probate. We're trying to protect from Medicaid putting a lien on after the fact. And that's where the revocable trust can be a tool in Medicaid planning, but it cannot be for other assets, because if you have full control over those assets, it will not be protected.
We did have another question come in. Upon death, any Social Security benefit can go to the trust, and Social Security office can deposit the checks directly to the trust, also 401k?
So the Social Security question is a little complicated, because a Social Security, if you're receiving Social Security payments on a monthly basis, at the time of your death, those payments stop. And if you've not survived the month, there's often a pullback of any funds that were given to you in that last month that you were alive. So I'm not sure that the Social Security are going to apply. If there are Social Security survivor benefits for a child or for a spouse, that's not going to go to your trust, because that's going to go to that individual that has the right to those benefits. In terms of a 401k or any other retirement account, same thing. While you are living, you can direct that those required minimum distributions or any distribution you're taking from that account be payable to any account that you choose to have it go into. So if you choose to have it go into your revocable trust checking account, that's something you can set up with your institution. At your death, that account is going to go wherever your beneficiary designation says it should go. So if I have a revocable trust and I have a 401k and it says that at my death, 100% of that 401k goes to my spouse, then it will be directed to my spouse. If my beneficiary designation says that that 401k will be directed to a trust for the benefit of an individual that I created under my will, then there will be a process by which the trust turns from my revocable trust with my social security number to the further trust that I have designated in that will with the terms and the rules that I say. It will get a social security number or an ID number from the IRS at that point, and then the 401k can be distributed out however is determined with the company holding the 401k to the trust, to an account in the name of the trust.
Thank you. We have one more question. We actually have two more questions. The first one is, can you convert from a revocable trust to an irrevocable trust, and what is involved?
So you can convert from a revocable to an irrevocable. What is likely going to be involved is a restatement of that trust, and it's going to be a conversation with your attorney to determine if that makes the most sense in your case, or if it makes sense to create a new irrevocable trust and actually transfer the assets from one to the other. So in it's very fact specific, but in certain circumstances, you will create a new trust and transfer the assets. And in other circumstances, you could do a restatement of your trust and make it irrevocable.
Okay, then we have another question. A friend in New Jersey said she had an irrevocable trust for her mother who just died. She found out that it still had to go through probate. Is that correct? Are there situations where an irrevocable trust has to be probated?
Okay, so New Jersey is going to be a different set of laws than New York. So I will answer that question as if that person lived in New York. A trust does not have to go through probate. Probate is a process that is only for a will. However, if you have an irrevocable trust, but not all of your assets have been put into that trust, if you have any type of trust and not all the assets are in the trust, probate may still be required. So an example, if I took my house, as I said, and I put it into my revocable trust by doing a deed, but I still have a checking account with $10,000 in it that's in just my name alone, I'm going to have to go, my will is going to have to go through the probate process for that $10,000 checking account to be distributed because it was never properly put into my trust and it was in my sole name. So it sounds like there might have been something that went a little awry with the plan in your friend's case. So it would depend on exactly what happened. But a trust does not go through a probate process.
Okay, Britt, at this point, there are no more questions. Did you want to finish up? Did you have anything else to say, or?
No, I think that's all mostly for today. Tune in on Thursday for a conversation with Robin Bernardalio for irrevocable trusts and all of the things that can be used for. Thank you for listening and have a nice day. Stay safe.